briefs on, and one of the questions they asked on, is how should we define bargaining units? And should we define bargaining units as less than the majority? What this is signaling is, in the very bottom, what's in black, is a consideration of whether they're going to approve mini unions. Mini unions are less than a majority of the members that are copying out. For example, take this room for example. If this table decided that they think that they all do the same job and they want to unionize, and that table did too, and that table said no, and this table did too, we've got 3 unions and 1 group of non-unions all of a sudden in the workforce. Why do I bring it up? Because it's been pushed by academic professors submitting papers. It's been pushed by briefs saying, for example, from organized labor, saying this is a good idea for workers, and businesses supply briefs that it's not. Currently, it's the majority of the workforce, and how you define that bargaining unit lets you know whether or not the people are going to elect to have a union or not, and whether an employer is going to be dealing with a union as they negotiate, or 7 unions, or 3. I kind of try and illustrate the point of anybody who has children, and all of a sudden different children want different things, and it makes it a little harder to have harmony in the household that way. So as a business person, as a business owner, a business executive or runner, this is something you should be aware of. The other things that they're talking about doing are speeding up the time frame for elections. Mark Pierce has already indicated in some of his discussions that he would like to see a very short period. I think it's 10 days, it may be 5 days or a week, whatever it is, he wants to see a short period. It's significant because if I'm a labor organizer and I've been organizing your workforce, and I've been doing it for months to try and get the signatures necessary on cards to ask for an election, you may not know that I'm making these efforts. Your first indication may be a letter from the National Labor Relations Board saying, Ted has gotten more than 30% of the cards, you're going to have an election. I may have gotten 60%. It doesn't matter, I need 30, that's my threshold. You may have first heard about it when you got that letter. Now if it says you're going to hold an election, which the average time currently is just under 2 months, you will probably try and figure out what you can and cannot say under the law, and the rules are strict, and you'll want to get your message out to the workforce how whether you want to be unionized or not. You may have been told by the union, we're trying to organize you, we'd like you to sign a neutrality agreement where you agree not to say anything at all. I don't think that's neutrality, I think that's silence. And I'm against those too, because I don't think they're fair. But the bottom line is, you may have been asked, you may not have been asked. You may first hear about it when the election's. If you then have 1 week to try and figure out how to get your point of view out to your workers before they vote, that's not a fair and balanced system. But the board is looking at, and Pierce has said, he believes that there should be a shortened time frame for elections. That type of ruling would not require a vote of Congress. It would require a notice of a rulemaking from the NLRB, a time period for comments from the public, and then a decision and a new rule being published in the Federal Register and enacted. Cyber card check. Cyber card check in our day and age of being technically advanced, in some respects may seem like a good idea. For example, when Delta merged with Northwestern, they have flight attendants, gate people, pilots, which I think comprise 3 different unions that were part of Northwestern and not part of Delta. They have them everywhere. And so a 3-week period to vote on computer, to cast your vote, from that standpoint made sense, because they don't have a central place where everybody is. Unlike a manufacturing plant or a brewery here, like Trogs that I see on the billboard coming up, they may have a central plant and all the workers may come in and vote. But the airline didn't. However, and the NLRB has sent out a notice and request for comment from people, how can we do ways of having electronic voting? The concern about the electronic voting is, I walk around with a BlackBerry. Some of you have iPads. Some of you have iPhones or Androids. If I'm trying to organize a workplace and I know it's a vote, if I can come up and lay an electronic device that's internet capable there and say, you should vote this way, and here you can use mine, there's a chance of undue influence there. There's a chance of peer pressure. Again, my whole position is, if people are going to vote on this vote, it should be without any pressure from either side. At the moment of making that decision, it should be pressure-free. And the danger in cyber card check is that using the devices like this, if that's now the new rule, then there's a danger that won't happen. Some of the rulings that I skipped over real quick, some of the rulings that the NLRB are doing, for certain unfair labor practices where there's been a settlement by an employer, they have required the employer to stand up and actually read the settlement to the workforce. I'm not quite sure why they did that, but I guess to really drive home the message. But it gives you a flavor of the board, that the board is really becoming polarized rather than neutral. The Department of Labor, and I can give you more examples later if you want on the NLRB. One example, for example, in some of the cases, they have in a decertification election where the employees voted to decertify and no longer be unionized, and it was by one vote. And the employer had actually signed a neutrality agreement in the very beginning. The board found that there was a passage in the employee handbook, even though it was never enforced, that said you're not allowed to solicit, you're not allowed to solicit on the property for anybody, anything. And they said that had a tilting effect, therefore we're not going to abide by the decertification election that the employees brought. This is an employer that never enforced it, never, and I don't remember the case, but if you want I can look it up and send it to you, that never enforced it and that never even took a hand in the vote because there was a neutrality agreement they'd agreed to in place. But on the other hand, the same board on an election, on a union election where it was also by one vote that the union did not get representation. And there was testimony that the union did not do what I'm about to share with you, but pro-union employees in the company did. They intimidated workers by saying, we'll be physically against you. They intimidated workers by saying, we will sabotage your job so that you get written up and get in trouble or get fired. Again, these were not union officials or members, they were pro-union employees. But our same board decided that didn't affect the election enough that was decided by one vote to rehold a new election. Now comparing the two and looking at the whole thing, that gives you an idea of kind of where the philosophy of this reconstituted board is. Why am I bringing it up? Because any new rule they come out with has to be open for a comment period. And when it's open for a comment period, people who are going to be affected should be commenting, regardless of which side you're on. And labor does this quite frequently, and business owners and business people need to also get involved through your local chambers. You've got a process to do it, but you need to get involved. Other things that you should be aware of, for example, DOL is cracking down on employers. They hired many, many new investigators in Wage and Hour and OSHA. That's the next slide. Let me go with Persuader. Persuader regulations are, if I'm a lawyer and I'm advising an employer who got this notice saying we're having an election, and what do I do? Currently, as long as I only advise the employer, I do not speak to the workers. I may be deemed a persuader, third-party persuader, but there's an advice exception. That's the attorney-client privilege or the advice exception if you're a consultant, not an attorney. You still don't have to disclose that. If I speak directly to the workforce, then I'm a direct persuader. And I have to file a report saying what I've done, who I am, who my relationship is, and may or may not, I'm not quite sure, disclose how much is being paid, but certainly the fact that I'm on retainer is going to be known. The DOL wants to eliminate or severely limit that exception. Why? What will happen if they do? What will probably happen if they do is a lot more people won't be doing that type of business. Because having to make the disclosures when they're trying to be very careful to speak only to the employer is all of a sudden creating more exposure. If that succeeds in limiting the number of firms doing it, limiting an employer's readiness to call up an expert and say, what do I do and how do I handle this? Then they will be less armed in the debate of whether there should or should not be a union in their workforce. If they are less armed, and they are not as knowledgeable as labor is, whose job it is to do this, and they do it very well, that's going to be an uneven playing field. So that's the type of regulation I'm saying I don't think is coming out that's fair, but also people need to be aware of, so that when the comment period comes up, and things like this, the comments can be submitted. Why are comments important?